Hello, good day and welcome to this session on termination of contract. By the end of this session, you should be able to explain termination of contract, explain some contract clauses in relation to termination, and explain termination for convenience. When we say termination of contract, it basically refers to an act that may occur wherein a contract can be legally cancelled before the contractual duties have been fulfilled. So, contract termination is done prior to contract execution because in the end, you are ending the contract before full performance is achieved. And it's done based on several reasons. And one should note that not all terminations of contracts would permit the escape from liability, such that not all contract terminations would allow the breaching party to go scot-free without providing remedies in whatever form to the injured party. And it should also be noted that contract clauses for termination should be clearly and explicitly stated in the contract so as to avoid any conflict in the interpretation of or in the determination of remedies available to an injured party. The duration clauses. Duration clauses are basically inserted into a contract to specify the date of commencement and the date of expiry for the contract. That is the date that the contract is considered to be effective. So, for example, it may be stated explicitly in the contract that the contract period is or the contract period begins from 16 June until 30th November inclusive, such that from this time to this time the contract is considered effective and the contract should have been discharged after this date. Then we move on to termination clause. Termination clauses basically specify the basis or grounds in which contract termination or a contract is deemed to be terminated, and they have to be explicitly indicated in the contract to enable interpretation as and when the breach or the termination occurs. So, a termination clause sets out the circumstances in which either party may terminate the contract immediately upon written notice to the other party. An example is the case of going into liquidation. So termination clauses may be embedded into a contract for several reasons. So one of them may be for termination for convenience, which is intended to provide the owner with the option to terminate the remaining balance of the contracted work for a reason other than the contractor's default. So an example is where the owner of the contract cannot obtain additional financing to complete the work. They can decide to terminate the contract or to terminate the balance of the work for convenience, as long as the termination clause is included in the contract. So we have established prior that termination clauses or duration clauses, whatever clause that you want to be bounded to be binding the contract, has to be explicitly stated in the contract. So termination for convenience clauses have to be stated in the contract so as to warrant its applicability in the contract. However, if the contract does not contain a termination for convenience clause, but the owner proceeds to terminate the contract, the contractor would be entitled to the value of the work that they have provided, in addition to a profit that they would have earned on the balance of the contract. So you would terminate a contract because you cannot continue to pay the contractor, but the contractor would have provided their services for a given work done. So the fact that you are terminating the contract because of your inconvenience or your convenience to not be able, which renders you financially unstable, does not mean the contractor should not be entitled to the amount of money. This would have this wouldn't have been the case, assuming the termination for convenience clause was explicitly stated and the grounds for application was included in the contract. So in Atos IT Service Solutions and Services versus Sapient Canada Incorporation 2018, though disagreeing on other issues, the Court of Appeal agreed with the trial judge's interpretation of the termination for convenience clause for the calculation of damages. In particular, the court held that the plain language of the termination for convenience clause required the general contractor, who is Sapient, to pay the subcontractor, who is Atos, for the last milestone prior to the termination, even though that milestone payment had been already paid. The court noted that the termination for convenience clause does not explicitly state that payment for the last milestone was only due if it had not already been paid. Accordingly, the court treated the referenced milestone payment as being agreed upon damages in the event of a termination for convenience. Then we have termination for insolvency. It's when a contract is terminated due to the effect that the other party suffers an insolvency event, which is usually broadly defined in the contract, notwithstanding that the other party is otherwise in full compliance with the contract. Then we have break provision. This is sometimes incorporated into contractual provisions for termination. It is usually inserted by buyers to give them the right to cancel the contract, regardless of whether any breach has occurred. So one can, given the explanation for break provision such that it is incorporated by buyers to give them the right to cancel the contract, regardless of whether any breach has occurred, it means that such a clause is arbitrary and may be construed as unreasonable. Therefore, it should state that the buyer will pay for the goods or services which have been wholly or provided to them prior to the termination of the contract, as well as the cost of materials and other resources which were bought in and which cannot be used. Then we have a transition clause. Transition clauses basically are incorporated in a contract to ensure smooth transition from a current supplier to a new supplier who may have been awarded the business for a new contract period. This clause should state that if there is completion or earlier termination of the contract, the outgoing supplier will cooperate during, without, or during with any handing over process. So, for instance, regardless of the reason for his departure from the employer, an executive agrees that at the employer's sole cost and expense, for a period of not more than 30 days after termination of executive, he shall take all steps reasonably requested by the employer to effect a successful transition of client and customer relationships to the person or persons designated by the employer, subject to the executive's obligation to his new employer. So you've learned about the termination of contracts as well as some contract clauses in relation to termination, and then finally termination for convenience.